All right, welcome to Housing Law Task Force on legislative history, how to use it, when to use it, how to find it. And with us is Rachel Hungerford. Thank you so much, Rachel. Rachel is the regional director of the Salem Lasso office. Rachel was a Oregon Supreme Court clerk, and then worked at the Legislative Council's office, and so is extraordinarily well positioned to give us this super useful information. So I circulated a sign-in sheet. Please record your attendance if you want CLE credit. I'll circulate it again after with the link to the recording. And without further ado, Rachel, thank you so much. Take it away.
Thanks, Emily. Hi, everyone. I'm Rachel. I use she, her pronouns. And thank you so much for taking a chunk out of your Friday to be here. I'm going to go ahead and share my screen. Okay, can everyone see the PowerPoint okay? Great, thank you. So I'm going to cover what is legislative history, when to use it, when not to use it, how to find it, and how to cite it. Got an interesting echo. Am I the only one hearing that?
We can hear it.
Okay.
You're echoing for some
How,
reason.
how is that?
Let's try it now. I don't hear it. Is that better? Perfect. So I tried to kind of make this accessible to a range of people's experience. I expect on this in this Zoom room we have anyone from somebody who's never done legislative history research all the way to folks who have done it multiple times. But I did sort of orient this more towards newer folks, not necessarily new attorneys, but those who haven't engaged in this particular type of research before. And I'll focus more on kind of the what is legislative history, what are all the components of a statute's legislative history, and kind of what are the relative weights that the courts will give to those different pieces, as well as the section on how to find legislative history. I find that that's often the most intimidating piece of all of this, especially if you've never done it before or just, you know, have not had a lot of grounding in Oregon's legislative process. It can be a little daunting the first time you need to do this to know even where to begin. It's very different than other types of legal research. So we'll focus on kind of those two parts, but happy to take questions throughout and hopefully have time for questions at the end. So what is legislative history? This can refer to a whole bunch of different things, but for today's purposes, we're talking specifically in the context of you are doing statutory interpretation. So for purposes of Oregon's very specific methodology on how we interpret statutes, the courts will look at text, context, and legislative history. And so for that purpose, legislative history means what is the record of how this bill made its way through the legislative process from when it was first introduced to when it was enacted into law. I'm not going to go through everything in this little comic strip. This is available on our state legislature's website. I included it, one, because it amuses me, and two, I think it's a good demonstration of how much more complex the process is than maybe your high school civics class made it seem. Right, there are a lot more steps than just a bill is introduced in one chamber, it goes to the other chamber, and then it goes to the governor. There are a lot of intermediate steps. And as I'll talk a little bit more later, Oregon's legislature has a very committee-heavy process as compared to Congress and as compared to some other states. So this may or may not be a useful reference point for you. I've also included in the materials an article by a former legislative counsel that goes much more into depth about each stage that's depicted here. And so hopefully that is a helpful reference material whenever you do get into doing this type of research. If you're not quite sure, some of the pieces of this process, like what is a work session, what is the second or third reading of a bill, there's a section in that article on each of those things. So what are the main sources of legislative history that you're likely to be using in your brief or memo? The main sources are statements made by legislators, which could be statements made during floor debates. It could be statements made during committee hearings or work sessions. It could be non-legislator statements, which I'll talk more about in a minute, or the history of how the bill was amended through the process. There are other components, but I would say these are probably the main types of legislative history that are going to be useful to you and persuasive to use in your brief. So legislator statements during floor sessions. A floor session is when a quorum of an entire chamber is present. So that is probably going to be more persuasive than statements made elsewhere, statements made in committee. And particularly if there's a statement made on the floor that's not otherwise contradicted, you can make a pretty decent inference that that accurately reflects whatever is being said about the meaning or purpose of the bill. In terms of legislator statements during hearings and work sessions, as I mentioned, Oregon has a committee-heavy process. So in Congress, for example, it's common for bills to be amended on the floor. That doesn't happen in Oregon. So much of the work in kind of fine-tuning a bill, and certainly essentially all of the amendments happen in the committee process. So having just said that the floor sessions are better evidence of an intent because you have a quorum of a whole chamber, likely in terms of the likelihood of you finding a useful statement to use, it probably happened in committee because that is where a lot of the policy work on the bill is done. Non-legislator witness statements, I'll talk more about in a minute, but there are all kinds of witnesses who come to testify about a bill. This would only be in committee. It could be members of the public, it could be lobbyists, it could be various types of legal experts. And as you might expect, there's different weight given to those different types of witnesses. And then amendment history can be really useful. So this is, you're going to look at the various versions of the bill. The introduced version of the bill can look extremely different than the final version, especially if the introduced version was just a placeholder, which is very common. Oftentimes, a bill will be introduced basically with the topic that legislators think they're going to want to fill in later, and essentially no substance to it. And so if you can, sometimes you can point helpfully to how did this bill change throughout the process. Another reference material I included for you all is an article by former Justice Landau on Oregon statutory construction. And he cites to an example of a case where the court relied pretty heavily on the amendment history of a bill to show they were able to show that a bill had been amended to change the word may to the word shall. And because shall can have multiple meanings, they were trying to suss out, was shall intended to mean must? You know, were they using shall in its mandatory sense? And it wasn't clear just by looking at the text. And then when you looked at the legislative record, you could see the bill originally said may, and they explicitly changed it to shall. And so that was, you know, a case where it kind of came down to legislative history, which I'm not going to say is a common phenomenon. And maybe a disclaimer I should put on this whole presentation is it's rare that legislative history will be sort of the thing that makes or breaks your case, but it could happen. So I mentioned I would speak more to non-legislator witness testimony, and that's because this is something you want to use with caution. I think it's maybe the source of legislative history people are most inclined to use, most excited to use, because probably it's the most voluminous. You may find, you're going to find more statements usually from non-legislators than from the legislators themselves. And so it can be really tempting as soon as you find anybody who came to testify before a committee who's saying something that is helpful to your cause. It's really tempting to sort of want to grasp onto that and make a big deal of it in your brief. And I would just counsel that you use some caution before thinking that that is the thing that will be most persuasive to the court. And for, I think, common sense reasons, right? These are statements made not by legislators themselves. And to the extent that the whole purpose of this exercise is to get at what, what did the legislature intend a particular statutory term or phrase to mean? You're taking several inferential leaps to say that, well, what some other non-legislator came in and said is what the bill means or what its purpose is, to then attribute that to the understanding of the full legislature, obviously is taking some liberties. So use with caution, not to say you can't use, but I think there are situations where it's more persuasive, and I've listed some of those here. So sometimes members of legislative council or committee council will come and testify on what a bill does or doesn't do. That tends to be fairly persuasive and reliable evidence, because those are impartial sort of legal experts. Legislative council is will be who drafted the bill. Committee council, not every committee has counsel, but some do. For instance, the judiciary committees in both chambers have an attorney on staff. And so if they're coming, it's probably somebody who had a significant hand in the drafting of the bill and is coming again kind of impartially to sort of report back on, usually in more complicated bills, here's what it does, here's what it doesn't do. And oftentimes the legislators themselves are not attorneys, so they are seeking that sort of legal counsel on the nitty-gritty of what the bill does. Another situation is the legislature may have specifically invited some entity like a commission or a task force to go look into an issue and then come back and report their findings. And so if that's what the non-legislator witness is doing, pretty reasonable to assume that the legislature is going to rely on those statements. And then the last category of fairly persuasive evidence here would be you have a qualified witness, which could mean a number of different things, but maybe somebody who again had a big hand in the drafting of the bill, was one of the original bill proponents, provides testimony before a committee, and again the statement goes without contradiction, particularly from any of the members of the committee. That, again, with some inferential steps could could show that the committee then relied on those statements.
Rachel, if I may, I'm going to just jump in real quick here. So when we're doing legislative research on Chapter 90 issues specifically, it's a slightly weird special case because up until about 2019, most of the amendments to Chapter 90 were proposed by a joint landlord-tenant committee. And so that group met and hammered out the details of bills and then just kind of offered them up to the legislature on a platter, and the legislature tended to just enact them because they're like, well, you guys already figured out, so whatever. This was in a different time when nobody really cared very much about landlord-tenant issues. So I think specifically for Chapter 90 research, those statements by the kind of like citizen committees are going to have a lot of weight because that's really the only legislative history there is. That's definitely not always going to be the case in other areas. Thanks.
Yeah, no, thank you. That's an excellent point. And I guess I would expand that to say it's even outside of Chapter 90, it's not uncommon for legislators to defer the vast majority of the policy work on a bill to others outside of the legislature. And so, you know, and particularly if the people who are testifying are the ones that the legislature has explicitly sort of delegated that task to, probably the legislature or the legislative history is going to be much more complete with their statements than with legislator statements. And you're probably much safer to use those statements as evidence of legislative intent. So looking at kind of the relative weight that's given to different types of legislative history, we've covered the first one pretty well. Statements by legislators generally considered more persuasive than statements by non-legislators. And the other two, so more equals better, very common sense, but I put that in there just because it can be tempting. Oftentimes when you do legislative history research, it's not particularly rewarding. I will say it usually takes hours of your time and you may come up empty-handed. Or maybe you found one statement and so you're feeling really good about that one statement and want to make a big deal of it. A little bit later, I'll talk more about some of the critiques that are out there of just why do we even resort to legislative history as a marker of legislative intent. And I think many of those critiques are valid. But to the extent that we engage in this fiction that our 90-person legislative body acts with a singular intent, what you're looking to show from your legislative history research is some sort of consistent theme, right? You're not going to find a singular statement that represents what all 90 members of the legislature thought. So instead, you're tasked with piecing together as many statements made throughout this process that can be woven together and from which we can sort of infer this is what more or less the body was thinking. So more is better, and a consistent theme throughout is better, and then specific as well. So I would caution against relying too heavily on any sort of broad statement about the purpose of a bill. This bill generally does X, and using that to then winnow down to what you think a particular statutory term was intended to mean. Again, that takes a lot of inferential steps. So what you're looking for is, were there statements made specific to the meaning of the term or phrase that you're construing? So have two slides here, one on kind of when might you use this and one on when might you not. And they're kind of the flip versions of one another, but I would say the main reasons to use legislative history would be either you're dealing with an ambiguous statute or the legislative history is going to bolster your textual analysis. And I'll talk about each of those more specifically in a minute, but just to kind of step back, I suspect that virtually everyone on this call, maybe everyone, is pretty familiar with our with Oregon's statutory interpretation methodology, but just to give a little bit of background, under the seminal case for a long time, PTE, courts would only look at legislative history. They would only consider it if, after first considering the statute's text and context, the statute remained ambiguous, meaning that it was susceptible to more than one interpretation. There's a big case, Gaines in 2009, that ostensibly changed that, but questionable how much it really changed it. So the legislature in the intervening years had, there's of course a statute on how to construe statutes, and the legislature amended that to basically say to the courts that courts, you can consider legislative history at any time. And the Oregon Supreme Court in Gaines interpreted that statute and concluded, yes, okay, fine, we can look at legislative history at any time, not just when there's an ambiguity. But the court sort of bent over backwards to caution parties that you're fighting an uphill battle if you're going to try and use legislative history to overcome the plain meaning of the text. And so, has all that much changed? I'm not sure really, you know, if the statute, if the text and context are super clear, there's no ambiguity, it's highly unlikely that legislative history is going to be helpful to you, because courts are not going to be persuaded that something you found in the legislative history should contradict what the statute clearly says on its face. So again, most useful if you're looking at a statute, you've examined the text, you've examined the context, and still that term or phrase could reasonably be interpreted one of multiple ways. Legislative history can come in and be essentially what tips the scales. If you look at the text and it could reasonably be interpreted to mean A or B, you look at the legislative record and there's a fairly consistent theme that everyone was assuming that term was going to mean B, that could be sort of your clincher evidence. Though, be curious, Emily, your thoughts, how often that actually happens.
I mean, I'm sure it must have happened at some point. But you know, the difficulty is that, I mean, we're lawyers. Our whole job is to make things mean more than one thing, and so that initial step couldn't mean more than one thing. It's like, well, yes, obviously, like that's just how language is. But yeah, it's much more difficult when the statute says X and you're like, oh, but the legislative history says Y. It's like, well, but they enacted X, so.
Exactly. In terms of using legislative history to bolster the text, I would say this is where maybe you have something shy of what you would call an actual ambiguity, but your analysis is a little shaky. Your text, you don't have a lot to go off of in your contextual analysis, and then the legislative history just sort of confirms what you're already trying to say. It can be powerful there too, right? To say essentially text, maybe all you have to go off of is dictionary definition. but it could kind of go one of a few different ways. There's not much in the context. And then again, if you find that great consistent theme throughout the legislative history, you can point to that to say, and this sort of supports the rest of the analysis. So I would say those are the situations where it's most helpful. In terms of when not to use it, it's a little bit the flip side of that. And unfortunately, one of these two situations you're not going to know before you have invested the hours. So the first situation is just when you have an unambiguous statute, and that you should know from looking at the text and context. If it's just not plausible that that statutory term or phrase could be interpreted one of multiple ways, stop there and save yourself the hours of diving through the legislative record. It's not, if the statutory term is really that unambiguous, you don't need to bolster your analysis at that point. And again, the court has cautioned all of us that you're fighting an uphill battle if you're going to try and contradict this clearly unambiguous text. So that's a situation where I would say don't engage in the research. The cost benefit analysis is not going to come out in your favor. The second situation, unfortunately, you won't know without putting the time in. But let's say you have a statutory interpretation question where you think the legislative history is going to be helpful. You do the research and there is nothing. There's nothing on point to the particular term that you're construing. Unfortunately, I don't know if it's time poorly spent at that point. You can't know that until you get into it, but I would say it's not worth including in your brief at that point. You've already done the research, but you know, I think there's it may seem obvious not to include the lack of legislative history in your brief, but I think there's a temptation to use the silence of a legislative record to show intent or the lack thereof, to say, for example, the interpretation that my opponent is proposing, is advocating for, can't possibly be what the legislature had in mind, because there's nothing in the legislative history that indicates that. Courts are not going to find that argument persuasive, and that for a number of reasons, but in particular, it is regularly the case that the legislature passes a bill with a very particular policy problem in mind that has nothing to do with when that statute later ends up before the appellate courts and they're trying to figure out what this particular term or phrase means in an entirely different context that nobody had in mind when the bill was under consideration. And so the legislative record is going to be silent on a whole number of questions, and it's not going to be indicative of what the legislature was quote unquote thinking. It's just going to mean that this situation that arose later was not on anybody's radar. Are there any questions at this point? Emily, I'm relying on you to monitor the chat. Let me know if there are any
I don't see any
questions before I
at
barrel
this
ahead.
point.
Okay.
I would just say, I don't know if this is your practice, Rachel, but when I'm dealing with one of these situations where I look for legislative history, there's nothing on point. I will often just say that, just so that the court doesn't think that I'm hiding anything. Just like, you know, legislative history doesn't reveal anything in particular as to the intention here. So we're just gonna go with like weird principles of grammar or whatever it is.
Agreed. I think that is best practice to show that you've sort of done your due diligence, but there's just nothing there.
Any other questions before we move on to where to find this stuff? All right, seeing none, we will move on.
Okay. So again, I think the mechanics of how you find legislative history can be what intimidates people the most. And I'll go through some of those mechanics in a way that hopefully doesn't put everyone to sleep, though I recognize not everyone nerds out on these things. But they're the mechanics of first, if you don't know the bill that enacted the statutory term or phrase that you're interpreting, there are mechanics to how do you figure out what bill you're looking at. And then after that, the mechanics of, okay, once you know the bill, how do you find its record? For newer legislation, if you're in our practice area, you might be very familiar, for instance, that the right of redemption comes from House Bill 2001 from the 2023 session, and you can go right to that bill and get straight to it. If you're looking at either older statutory text or just one where you don't know much about how it came to be enacted, then these initial steps are going to be critical for where you even start. And you're going to start by using the session laws to find exactly when, again, the text you're looking at was enacted and what was the bill number for that session. And the session laws, I think probably most people are familiar with, but in terms of what's the difference between the session laws and the bill, and the session laws versus the Oregon Revised Statutes. The session law is just it's the fully final version of all the laws passed in a session. So a bill passes out of the legislature and it's the enrolled version of the bill. Once it's been signed by the governor, it's a session law and it goes into Oregon's publication. Compiling these is just very helpfully named Oregon laws. So you will be looking in the, I'm going to go back a slide actually, because the background here is the Oregon laws are available going back to 1999 on the state legislature's website. If you're looking at session laws older than that, then you'll need to actually resort to book research. The Oregon laws are available in essentially every law library. And then in terms of session laws versus Oregon Revised Statutes, the session laws, why do we have that publication? It's because Legislative Council doesn't compile all the bills that were passed into the Oregon Revised Statutes until they'd be working on it now, fall after long session. So it happens once every 2 years. So in that intervening time, where do you go to find the laws that were passed? You go to the session laws. So your first step, and I've used the rent increase statute as an example here. So hypothetically, let's say the thing that we're researching is with the rent, and this is going to be a situation where we have where we know when this was amended, but you could pretend that we didn't. The rent increase caps that were passed in 2019, and we're curious about the exception for here 7B. I know this is really tiny, but the dwelling unit is regulated or certified as affordable housing by a federal, state, or local government. And I think this is what I had in mind. Sorry, I'm losing my place. I made the font too tiny even for myself, but I think I was looking for the exception for if it's subject to a subsidy. We want to know, when did that text get enacted? First, you want to look at the source note. The source note is at the end of the statute, and it's just a string citation of all the session laws, starting with the session law that enacted that text. And then the subsequent cites are going to be every time that statute has been amended since. So enacted in 2016, amended in 2019, 2021. When this gets compiled next, it should show one in 2023 as well. And if you, again, in our hypothetical where we don't know when it was amended, I mean, it's always nice if you have a good sense of what time frame your statute was amended. If you don't, you may just be in the position of checking each of these session laws until you find your text. So here is the text I'm looking for. When you look at the session laws, it'll look like, if you have read bills before, the session law will look similar, where language that got added is in bold and language that got deleted is in italics and brackets. So you want to look for bolding of when did this language get added. Once you know that, you go to the top of that session law and it will identify the bill number. So this is one, again, within Housing Law Task Force. We're probably all very familiar with Senate Bill 608 from 2019, but this is how you would, if you weren't familiar with that history, you would trace it back. You would look at each session law identified in the source note, check the session law. Is that where your term or phrase got added? If so, then look at the beginning of that session law and you'll find the bill number. So it's going to be Senate Bill 608 from the 2019 session. All of that has to happen before you can even start looking for the legislative history. You have to know the history of which bill. Once you know that, you're going to be going to one of two places. And I always not so secretly hope that I'm going to OLIS and not to the state archives, but it depends on the age of your bill. So I suspect this will eventually change, that archives and or the legislature will eventually put more and more things online. But as it stands right now, bills from 2007 to the present are on OLIS, is the Oregon Legislative Information System. It is much more user-friendly than digging through the state archives. So that's a fun adventure unto itself if you've never done it. If your bill is from before 2007, that's where you're going to be headed for your research. And then in terms of what you'll be reviewing, so you have your bill now, you're either in OLIS or going to the state archives. The main things that you're going to be either reading through or listening to are going to be the different versions of the bill, staff measure summaries of the bill, fiscal revenue impact statements may or may not be relevant to our work, but occasionally written exhibits, and then audio or video recordings. So the next slides, these are all pulled from OLIS. Again, if you're lucky enough to be doing this research the easier way online, here's kind of what it will look like. If we have time, there's one thing I may actually show you on OLIS how to do, because there's one thing I find less intuitive than the rest. Archives, I'm not going to go into in detail, though happy to answer questions on how to go about that research. The reason I'm not going to go into detail is just the State Archives does have full-time research staff that are there and can answer questions. So first, looking at the bill versions and its amendments. So on OLIS, this is really easy to pull up. You go to the text and there's a drop down of all the ways in which the bill was amended. The introduced version is just the first version, which again can be a very unhelpful placeholder bill, or maybe sometimes you see bills that really change not at all, and the introduced version could be nearly identical to the enrolled. It will also list any amendments that were adopted. There's a separate tab in OLIS. There's an amendments tab that's going to list all of the amendments that were proposed. But when you're looking at the bill versions, the amendments here are just the ones that passed out of committee.
Can I just jump in briefly there and make a plug for looking at the full amendment history, just because sometimes, particularly if it's a somewhat contentious bill, there will be amendments that are trying to make the statute say something in particular. And if those proposed amendments fail, that can be a useful way to argue that, okay, that wasn't it. Like whatever it was that the proposed amendment said, we know that that's not what it actually says because they rejected it. You know, you can poke holes in that argument, but it is a helpful argument to make.
Yeah, great plug. Thank you. And I'll also just say, as kind of not a warning, but just kind of know going into it, reading amendments is sort of a weird exercise if you haven't done it before. The legislature is required to do line by line amendments. And so you'll be reading these very explicit instructions to, like, in line 3, delete X text and add this. And so it's sort of, it's not a very useful way to read through it. If you have the option of, so what Emily is suggesting is excellent, which is to look at the amendments that were considered and not adopted too. And those will be all in that sort of wonky form. If you're looking at amendments that were passed, they're going to be much more readable in the engrossed versions of the bill. And the engrossed versions of a bill are simply once those line by line changes have been incorporated into the bill, and then it reads like a normal bill again. And those are lettered ABC, et cetera, just to indicate, you know, the A engrossed version of the bill incorporates the first set of amendments. The B engrossed is going to be, it's gone back to some committee and had further amendments. And the enrolled is the final version, other than it doesn't have the governor's signature yet. Staff measure summaries can be useful depending on your issue. If your issue kind of ties in some way to the overall purpose of the bill, then this could be a really helpful tool, because the staff measure summary is going to give a synopsis of what the bill does and a pretty good background on why did this bill come about, what was the policy issue that was in mind. So if that happens to connect with your issue of statutory interpretation, great. But as I mentioned before, it often doesn't. Often this is going to reflect, here's what the legislature was really looking at and considering, and your issue is going to be something altogether different. And I have a note here that this is updated as the bill changes. So there may be multiple summaries as the bill kind of morphs through the committee process. Fiscal and revenue impact statements may or may not be at all relevant to you, but if there is a sort of monetary component, obviously these are going to be very relevant. This is an analysis of how The fiscal impact statement is going to be how spending is affected, how revenue is affected. But it does include kind of like the staff measure summary, an overall analysis and synopsis of the bill. So if nothing else, these can get you sort of grounded in what was this bill originally intended to do, even if it's not what you cite to in your brief. Exhibits, this would include written testimony that's submitted. So oftentimes for public hearings, proponents and opponents of a bill are going to have submitted written testimony and also will come and give oral testimony. There will be witness lists of everyone who came to testify. Sometimes there are floor letters for the floor sessions. I'm not sure those are often helpful, but the legislators can, and with some regularity do, sort of introduce while they're carrying a bill on the floor, some news article or something they think is relevant that people should consider in conjunction with the bill. And then the next part that oftentimes can be the most fruitful for you are going to be the actual recordings of the committee hearings and floor sessions. And I have just a note of caution that these are not transcribed. You get to be the transcriber. So plan on whether it's pen and paper or on your laptop, but kind of writing down to the extent you want to quote anything from the legislative record, you will be the one writing it out word for word from the recording. In terms of what recordings you're going to be listening to, public hearings and work sessions are the sort of big things that happen in committee. At the public hearings, you're going to have, as I mentioned, written and oral testimony from usually a wide swath of people. Again, everyone from just interested members of the public to key stakeholders who've been really like hammering out the policy at issue, to legal experts, which could be legislative or committee counsel, could be attorney general's office, the bar. Sometimes the legislature will invite any number of people they consider to be legal experts on the matter to come testify. And then the work session may be held separately, but often is held immediately after the public hearing on a bill, usually much shorter than the public hearing. The work session is for the committee members themselves to hammer out the bill and make decisions. So after they've heard from the public, they have what's called a work session where they, the members of the committee, debate the bill and then hold a vote, and it will either pass with the amendments they were considering or not pass. Floor sessions, and this is the one, if there's time at the end, I might show you on OLIS where to find these, because again, this is a screenshot from OLIS, and they make it really easy when you look up the bill to find a public hearing was held on X date, and here's, play the video for it or the audio for it. The floor sessions take a little more digging to find, but essentially you're looking for the third reading of the bill in each chamber. That's when they held the floor debate. A floor session is just the full chamber or the quorum of the chamber that's present debating the bill and taking a vote. Again, if you have statements relevant to your issue that were made in the floor session, that's excellent. It just, because so much work on the bill happens in committee, is probably a little less likely to happen. Oftentimes the floor debates are sort of big, lofty, big picture policy debates rather than about the details of the bill. And then one kind of word about OLIS versus archives here. In OLIS, another reason I find OLIS to be very helpful, there are recording logs that are hyperlinked. So you can go exactly to the spot in the audio or video that you're interested in. So if I want to go straight to Sybil's testimony on something, I can click on that and it goes to that point in the recording. Obviously, OLIS, things that are not online are not going to have that nice link to take you directly to where something happened, but there will be committee minutes, and they're structured similarly. It'll set out the minutes of what happened in the committee and who spoke when, but you're going to be listening to, depending on the age of the bill, cassette tapes, or maybe you're using a reel-to-reel player, which is a fun experience, and trying to pinpoint where that statement was made. The one thing that I think is more helpful about the committee minutes is that they do include a synopsis of what was discussed. Though I will say there's an express in the appellate court style manual, there's an express caution against using committee minutes, citing to them for anything other than to show that a particular action, like a vote, was taken. If you're trying really ultimately to cite to what was discussed, you're going to be citing to the recording itself, not to the committee minutes.
And just one more note about Chapter 90 legislative history specifically, because we have uniquely privileged access to John Van Landingham, who was one of the prime movers on the Landlord-Tenant Committee for most of the time that it existed. We actually have a lot of the legislative materials in our, private holdings. So for stuff that is pre-2007, before you plan a field trip to the archives, I mean, unless you really want to go to the archives, which are awesome, and totally do it if you want to, but check with me because we probably have those materials already.
Thank you for that reminder. That would be a much better step than the archives if you don't have to go there. So last thing I'll talk about very briefly is how to cite. And this, mainly in terms of the technical requirements, what's the citation format you use? You're going to be looking at the Oregon Appellate Court Style Manual, and they have a whole section on legislative history that provides some helpful examples for different types. How do you cite it? This is from the style manual and just shows some examples. You can tell this was written testimony because it shows that it was an exhibit, versus the next ones are somebody citing to actual recordings of what was said. For an older statute, again, you can see this is a tape recording, and you have tape such and such side A, versus newer legislation where you can just sort of you're going to be able to pinpoint exactly where the statement was and cite to OLIS. So I'm not going to go into any more detail in terms of technical citation style. I think the style manual covers that pretty well. But the question of how to cite, I think, also gets at how to effectively cite or use legislative history in your brief or memo. I have a little excerpt here from Emily's wonderful brief in Hickey. I thought it was a good example of what we were talking about earlier about how you can use legislative history to bolster your textual analysis, right? So she has, and she's cited a statement by John Van Landingham. So she cites that from the record and then says, in that definition that they were talking about, in committee supports the plain meaning of the term as provided by the dictionary, so sort of linking it back to the analysis she had already made in her textual section. And then I threw an example of how it gets, how legislative history gets cited to by the courts. You may remember an email from Emily in May, I think, about a long convoluted case relating to whether there's a discovery rule that tolls the 1-year statute of limitations in landlord-tenant cases. And the court relied pretty heavily on legislative history in that case. I think that doesn't happen all that often, that you see opinions that are really going into detail about the legislative history, but this one did. So I have just kind of an excerpt from that and how they used committee exhibits. Here's an appropriate use of the minutes. They're citing it to show that an amendment was adopted. And they kind of used, they used the amendment history of the bill to make certain points. And ultimately, I mean, the whole analysis kind of came down to that something was a editorial decision by legislative council rather than a substantive decision by the legislative body itself. So it was a case where the legislative history actually mattered a lot. I think that's all I have. Maybe I can just show quickly the floor session piece on OLIS, and then I will take any questions people have. Okay, are you now seeing OLIS? Great. So here's what, when you go to OLIS, here's what the main page will show. It will default to wherever they are in the current biennium. So right now we're in the interim. So the first thing you want to do is get to the right session. So let's say we want to find the floor sessions for, let's use House Bill 2001 again. So, excuse me. You want to go to the 2023 regular session. Look up your bill. Oops. Here it is. And the reason I say floor sessions are not as intuitive as public hearings and work sessions is when you go to the bill's history down here, it shows you very clearly public hearing was held, public hearing work session was held. I can click on these and it will link directly to the recording. Whereas you're not going to see in this list where were the floor sessions. Again, the floor sessions happen at third reading of the bill. I think your clue is going to be, you can also see that a full vote was taken at the third reading in each chamber. And so it's not hard, but it takes an additional step basically of, so I want to look at the floor session that happened in the House. It looks like it happened on March 15th. Then I need to go outside of pretty much everything else for the bill is going to be on this page in one of the tabs, but the floor sessions are housed elsewhere. So I'm going to go back to the session. That main page has essentially what happened on the floor, the first, second, third readings of the bills. And so you're going to go back to the main page for the session and then go to the date you're looking for. So we said March 15th. And I wanted the House third reading. And here I can see, now here's House Bill 2001. And so from there you can click, you can also use you can see other things were discussed. So I would probably click, but then go to the recording log, unless you really want to hear a lot of the hot air that happens at the beginning of these sessions. I would go to the recording log to find out where did they actually discuss House Bill 2001. Here's where it starts, and that's where I would start listening. All right.
Rachel, thank you so much. What questions do folks have? I know that that was a lot of material, and thankfully Rachel has a lot of stuff that you can review, but for those of you who are still with us, have you had occasion to use legislative history? Do you have questions about when or why? What else can Rachel provide while she's here? Okay, so this is like physically painful for me. So I'm gonna talk. Okay, yay,
has a
Beth,
hand up.
thank you. Save me from myself.
Oh my gosh, I was just like frantically trying to figure out what button to press. So sorry for the awkward delay. Oh my gosh, Rachel, that just is so, just the way you laid that out is so calming, and it just makes it seem so doable. I love how you've explained it, and the written materials are great too. When I feel like sometimes we need to make the leap between the legislative history and the rules, administrative rules that come out of statutes, that, you know, that kind of spawn agency rulemaking. Are there any special considerations when you need to do that? And maybe how do you have suggestions for how people should work back from an administrative rule to this process that you just described?
It's a great question and a hard question, especially to answer concisely. I think so a couple of things, you know, if you're trying to make the connection of back to the statute in terms of, was this rule sort of within the intent and scope of the enabling statute, right? Did the agency have authority to promulgate that rule? Then I think the process is not going to be any different, right? You're going to be focusing probably on the legislative history of the statute at that point and just linking it to then what did the agency do with that. To the extent the question is sort of doing this type of research, but with how an agency rule came to be passed, I think that's can be a whole other ball game. It's a different process, and I think there are less, certainly the process of creating statutes is very imperfect, and we end up with a lot of ambiguous text. That's why it ends up before the courts. But that being said, I would say with agency rules, all the more so, there are fewer, you don't have a designated entity like legislative council doing the drafting of those rules. And so I think it's far more common that you end up with sort of maybe not nonsensical, but confusing rules. I'm not sure if that is a helpful response. Emily, do you have other thoughts on that one, or guidance on how to approach that? I do think like the process of how doing sort of the history of an administrative rule would be a whole other topic unto itself in some ways.
Yeah, very much agree. For the purposes of this training, yeah, I agree that looking at the legislative history of the enabling statute is going to be simpler, particularly if your goal is to show that the agency has gone beyond the scope of their authority. But yeah, the rulemaking process is yes, something else.
You.
One thing that I kind of want to talk about before everyone leaves, and we definitely don't have to sit here staring awkwardly at each other until noon. I'm not that much of a sadist, but I often find this situation where folks, whether other folks in the program or other attorneys that I'm working with, or sometimes judges, I'll give them the statute and say the statute says do this, and they'll be like, are there any cases interpreting that statute? And it's like, well, I mean, no, right? Like I got an email from a private attorney the other day who wanted to know what case law was there for HB 2001. I'm like, well, like it just got passed like 5 minutes ago. Like, give a girl a minute. But also, the provision that he was exercised about was the provision that says a court shall dismiss a complaint that doesn't have the required documentation attached, right? So it's not there, like there's nothing to argue about there. Like it just says that the court shall do that. And so I feel like there's a tendency where people feel like just the text of the statute isn't enough. Like you need the text, and you need a court that says this means what it says, and you need legislative history that says yes, we actually meant what we said. And I just want to say you don't need all that. Like you're perfectly competent to read the statute and say, well, this is what it says, this is the plain meaning of the terms, and unless there is something weird there, you get to just proceed. Like we don't have to look for the secret text that's behind the plain text unless we really need to. And sometimes you'll get that from judges too. They're like, can you give me some briefing on the legislative history here? And I'm like, I mean, I'll look because it's a judge, but you're just like, it's just what it says. Like I can't help you.
Yeah, I couldn't agree more. I mean, as I mentioned, I thoroughly enjoy all of this, kind of nerd out on it, and I'm the first to admit that its usefulness can be limited, and the amount of time it will take you is extensive. So I think it's worth doing that cost benefit analysis before you dive into this.
One other thing I will suggest before you dedicate a lot of time to researching the legislative history of a particular provision is look at the case law involving that particular statute. And obviously that's going to be more relevant for an older statute because, as I mentioned, it takes a minute for courts to start getting case law and stuff. But oftentimes the legislative history will appear in the cases interpreting that statute. So someone has already done that work for you, and that can be super helpful. And I am going to count to 15 in my head, and if no one has any questions, then we will call it a day. Oh God, it's agonizing. Okay, thank you all so much, Rachel. This was so helpful. Really appreciate it. I am going to turn off our recording.